Good afternoon. I'm glad you could join us today. Today, our guests will discuss the Fourth Amendment rights on school grounds. How many of you are familiar with your Fourth Amendment rights? Our nation has a lengthy history over the protection of citizens' rights against unreasonable searches and seizures. In 1984, the Fourth Amendment rights of a 14-year-old in New Jersey was challenged. She was suspected of smoking in her school bathroom, and based upon suspicions, her purse was searched and more drug paraphernalia was discovered. The case rose to the attention of the Supreme Court and argued in favor of the school. What do you think warrants a search of someone's personal possessions? Today we'll find out. Here with us now, in support of the student, is her lawyer, Lois T.L.O.
Hello, Katie.
Hello. Tell us about your client.
T.L.O., her identity is confidential since she was a minor, was a 14-year-old freshman at Piscataway High School in Middlesex County in New Jersey.
Was there another girl involved?
There was another girl who was smoking in the bathroom, but she was let go since she confessed. You're allowed to smoke at the school in designated areas. The girl just did a minor offense by smoking in the bathroom. This small violation of school rules does not warrant the search of belongings, which led to the charge of possession and dealing of marijuana for T.L.O.
So have they confessed?
No, the other girl confessed, not T.L.O. She did not admit to smoking in the bathroom, and the principal grabbed her purse and searched it without permission. The principal is an employee of the state, not a parent, and therefore he has no right to go through the belongings of my client. The principal must protect the rights of the student, and including the right of privacy. And the search and seizure of T.L.O.'s property was unreasonable and led to her confession. So in this situation, the exclusionary rule, which states that because evidence was found or analyzed in a way that violates a client's privilege, that the evidence is unwarranted in court.
Interesting. Now that we've heard your side, let's take a look and see what really happened.
I found these two girls smoking in the girls' bathroom.
Ladies, is that true? Were you smoking?
Yeah, I was.
Terry, were you smoking?
I've never smoked and I never will smoke.
Is this your bag?
Yeah?
I'm going to look in this bag. Cigarettes. Terry, are these yours? Explain those. Water bottle. Can you explain who these people are and what these mean? Terry, these are rolling papers for cigarettes. Can you explain how these are in your bag? Can you explain the crack cocaine? I'm going to have to call your parents.
This is the label on it.
I definitely think that the girl's violation of school rules validates a search of her property. But why don't I give our next guest a chance to tell us all about this? Let's give a warm welcome to him, the lawyer for the state of New Jersey and in support of the school, Alan J. Knowles. Have a seat. Thank you for coming.
Oh, it's my pleasure.
In your opinion, what ensures the right of a principal or a teacher or any other school employee to search the personal belongings of a student?
Well, when you or any parent sends their child to school, they expect school officials to protect the well-being of their child, correct?
Of course.
When a child is on school property, they abide by the rules of the school, like a visitor does at your home. School officials, like Assistant Principal Mr. Choplick, are the acting parental authority at the school. The search was provoked by the breaking of school rules on school property. The student, T.L.O., behavior provoked a reasonable search of her purse, and therefore the exclusionary rule does not apply.
I definitely agree. T.L.O.'s behavior prior to the search of her person, of her purse actually, created like suspicion of drug on her person.
Yes, exactly, which warrants the search.
All right, well, thank you so much for your time. And next we will have Supreme Court Justice Warren Burger. Welcome back. I'm here with Justice Burger. Tell us a little bit about how the case escalated from a juvenile court sentencing to the attention of the Supreme Court.
All right, well, first, thank you for having me today. It's my honor. I've always been such a great fan. So at first, T.L.O's case was decided by a juvenile court, who first sentenced her to 1 year's probation. However, T.L.O decided to fight her sentence because her Fourth Amendment was violated during her search and seizure at the school. And the court went to the Supreme Court of New Jersey. The court overturned the decision of the juvenile court, stating that the Fourth Amendment rights had been violated. But then they asked the Supreme Court of the United States to hear their appeal. My court ruled in a 6-3 search was reasonable under the Fourth Amendment. We concur that school administrators need to have a reasonable suspicion, which the principal, Mr. Choplick, had.
Well, thank you for your time, Justice Berger. The decision of the case was used a number of times in the 1990s in relation to other protective cases at schools, in regards to airport scannings and cell phone searches and drunk driving incidents. The ruling of the Supreme Court case in New Jersey v. T.L.O. has been used and will continue to be used as a guideline for Fourth Amendment cases. Thanks for joining us today, and I'll see you next time on The Daily Show with